Okay, what are antitrust laws? These are laws that seek to protect consumers by preventing unfair or anti competitive practice by individuals in the market. Okay, that is, competitors for providing goods and services in the market cannot undertake anti competitive activity either individually or in concert with others that somehow diminishes competition in the market and then thereby negatively affects consumers. Competition has a positive, or generally understood to have a positive impact on a consumer. That is, it makes goods and services more available and it generally pushes down prices. Okay, and that combination there is sought after for general economic prosperity and development, but also generally the protection of the rights of individuals. Now, antitrust law got its name because early on, these titans of industry, as they were called, would form trusts to hold multiple companies, and these trusts would thereby undertake some level of concerted or anti-competitive activity that would give these companies an advantage. They would not compete with each other or would limit their level of competition, and ultimately that would limit the supply of goods or services and would raise prices for consumers. So it had a negative impact. And to break up these trusts, the federal government began passing laws. Originally, this was just matters regulated by states, but then the federal government came in and began passing laws to break up these trusts. So thereby came the name. Now, the interpretation of what is antitrust now is far broader than just the trust ownership scenario. It generally includes any form of anti-competitive activity, particularly when there is concerted activity by competitors in the market. So we'll visit the primary laws governing or providing for antitrust provisions, and then we'll talk about some of the details of each of those laws, specifically the types of conduct that is prohibited thereunder.